Thank you, Presiding Officer. To ask the Scottish Government what its response is to reported comments from the Scottish Solicitors Bar Association that its plans for juryless trials would be an affront to justice and that any proposed pilot could result in boycott action.
Cabinet Secretary Angela Constance.
Presiding Officer, I am, of course, disappointed that some criminal defence lawyers are not in agreement with some of the recommendations flowing from the review carried out by Lady Dorrian, Scotland's second most senior judge. The European Court of Human Rights has explicitly ruled that a jury is not necessary to deliver a fair trial. Trials without juries are not undemocratic or inherently unfair. Over 80% of criminal trials in Scotland are conducted without a jury currently. There is, of course, overwhelming evidence that false beliefs and preconceptions influence jury decision-making in cases of rape and attempted rape, which, coupled with the significant and long-standing disparity on conviction rates in these cases, is a cause for concern. Therefore, a time-limited pilot of single-judge rape trials will enable us to gather objective evidence to inform the debate on this issue and is entirely compatible with an accused's right to a fair trial. And we have, of course, been working closely with stakeholders, including the legal sector, on proposals and will continue to do so.
Jamie Greene.
Can I thank the Cabinet Secretary for that response? It is, of course, true to say that everyone wants to improve outcomes for victims of these horrific crimes, but the Government's proposals for juryless trials has resulted in a significant backlash from the judiciary. Now, the Cabinet Secretary just mentioned the ECHR. She'll be aware of Lord Uist's comments today, a retired senator of the College of Justice, who described the pilot and its ministerial review as, I quote, constitutionally repugnant, which constitutes a serious attack on the independence of the judiciary. He went on to say that a court with limited lifespan working under such constraints could not, in his view, be considered an independent tribunal within the meaning of Article 6 of the ECHR. The Faculty of Advocates described the proposal as anti-democratic, and the Bar Association themselves made the very stark claim that no other civilised country dispenses with juries in such cases. They will actually go as far as balloting their members to potentially boycott these trials, which makes a complete mockery of the pilot itself. So I suppose the fundamental question I have for the Government is this: what makes them all so wrong on this matter and the Government also right?
Cabinet Secretary.
Presiding Officer, we are at the very start of a parliamentary process where the Victims' Witness and Justice Reform Bill will be debated in detail and, of course, scrutinised, I hope, to the very highest of standards. And for my part, I am absolutely determined to have the highest standard of debate on these matters and indeed scrutiny, where we are focused on the substance, because we need the people of Scotland and indeed victims and complainers to be proud of the debate that we are about to embark upon. Now, of course, the recommendations in hand, yes, are being put forward by the Government, but they, of course, come from significant deliberative recommendations of a cross-sector review led by Lady Dorrian, who said and recommended that we gather evidence to inform this debate so that we can move forward and we can establish whether in its treatment of rape and serious sexual offences do we have a justice system that is fair and balanced to all involved. And that, bearing in mind the evidence that we do have around conviction rates and the prevalence of preconceptions, seems like a very legitimate inquiry to have. And it may also be of interest to the Chamber, Presiding Officer, that there is no single approach to the use of juries in criminal cases in other comparable jurisdictions. New Zealand, for example, and indeed France, have moved away from jury trials for particular sexual offences cases. So there is a wealth of evidence out there that we need to debate, look at and inform our approach going forward to do our best by women when they are at their most vulnerable, but also to ensure the integrity of the system for everybody involved.
Jamie Greene.
Look, I agree with much of what the Cabinet Secretary says. I keep an open mind on the outcomes of this legislation, but we cannot ignore what are very serious, I think, and direct pieces of feedback from senior members of the judiciary. The Cabinet Secretary wrote in the media over the weekend that the principal rationale, I think, for juryless trials was because I quote, "There is overwhelming evidence that jurors are subject to preconceptions about rape." So I guess my first question is, if that be true, then why would the answer to that simply be to remove juries altogether and not to educate or improve the jury process? The Scottish Government has done very limited research into this issue, which has drawn much criticism, and it also fails to ignore other forms of research into this, including that by the University of London, which quizzed real jurors about the so-called myths and stereotypes around these crimes. So my question to the Cabinet Secretary is, if in advance of introducing legislation which removes the accused person's fundamental right to a jury trial, will the Government commit to immediate and comprehensive research into jury attitudes here in Scotland, using the real-life testament of jurors who have tried people in rape cases, so that any policy change is driven by evidence and not just by assumptions?
Cabinet Secretary.
Presiding Officer, it's important that we recognise that the existing evidence and the existing views, whether that's of victims or indeed parts of the legal establishment, that does not in any way negate the need for other research and measures. And of course, there was a number of recommendations made by Lady Dorrian that are already being taken forward by the judiciary. But this debate we are having needs progress. Some of these issues are long-standing and we've been debating them for around 40 years. So we now need to make progress for all involved and in particular victims who I think we all agree in this chamber that we need to improve that end-to-end justice journey. Now, in terms of the evidence, can I point members to the policy memorandum that actually quotes and examines a range of evidence? We will, of course, have further discussions and debates around that. But if I point to paragraph 544 in the policy memorandum that states, and this is based on research from 2023, that research examining the existence and influence of rape myths is now vast and empirical evidence is reliable enough to conclude that widespread endorsements of rape mythology spans varied societies, cultures and distinct social groups. And members are perhaps also aware of the work by Professor Fiona Leverick, Professor of Criminal Law and Criminal Justice at the University of Glasgow, who states there is overwhelming evidence that jurors take into the deliberation room false and prejudicial beliefs about what rape looks like and what genuine rape victims would do, and that these beliefs affect attitudes and verdict choices in concrete cases.
I will take some supplementaries. I will require more concise responses, Cabinet Secretary. I call Audrey Nicholl.
The Lady Dorrian review acknowledged several benefits that could be achieved through single judge trials, including reducing the impact of rape myths. Does the Cabinet Secretary agree with the review that reducing the impact of rape myths is a very important factor in removing stigma and ensuring a fair trial for survivors?
Cabinet Secretary.
Presiding Officer, removing the impact of rape myths on jury decision-making is, in my view, absolutely vital to ensuring that we have a justice system that is fair to both complainer and accused. The evidence shows clearly, as I've referred to earlier, that this balance is not being achieved at present due to the impact of cultural misconceptions or indeed the stigma that Ms Nicholl refers to. Therefore, conducting a time-limited pilot provides us all with an opportunity to explore whether single judge trials can mitigate the impact that currently exists on jury decision-making in cases of rape and attempted rape.
Christine Graham.
Thank you very much, Presiding Officer. Can I register my concern regarding juryless trials, let alone a pilot in rape cases? For example, the right to appeal, let alone appeal itself, a judge-only conviction compared to that of a conviction by a jury, to me, raises serious issues of parity of right to justice.
Cabinet Secretary.
Presiding Officer, perhaps I would be helpful to the member if I actually quote from Lady Dorrian's review again, when she said that consideration should be given to develop a time-limited pilot of single-judge rape trials to ascertain their effectiveness on how they are perceived by complainers, accused and lawyers, and to enable the issues to be assessed in a practical way rather than a theoretical way. And also to say to Ms Graham that as we proceed with the detailed work that is already commenced, that there is already a number of recommendations made about case criteria, objectives and evaluation. But the recommendation was for us also to do further work in and around these matters, because we need to ensure the integrity of the system and to ensure that the matters of appeal and fairness, both to victim and accused, that we get the right balance between being bold, but we protect the integrity of our system at all times.
That concludes topical questions.